Hey everybody, welcome back to the channel today. As promised, but not always on schedule, we have another lawsuit entering the Second Amendment community here in California. It is the Second Amendment Foundation v. Bonta. This is in regards to the 10-day wait that we have in California. Here to talk about it with us today, we have Chuck Michel, who is the CRPA president and the senior partner at Michel and Associates. Chuck, thank you so much for coming on with us.
Always a pleasure, fellas.
Before we get into this today, I wanted to remind you all, be sure and hit the comment section down below. We are still doing the giveaway for our 10,000th subscriber. We're inching ever closer to hitting that milestone. You can help us reach it by commenting hashtag CRPA for the win. It'll enter you into a chance to get a Springfield XD giveaway that we are doing. And also, while you're at it, hit the like, share, and subscribe buttons. That's what helps us hit these milestones in the first place. As always, we're trying to spread this information as far as we can. You can really help us to do that by hitting those buttons. So I guess, Chuck, coming down into this, we've got another lawsuit. It's challenging the 10-day wait. I'm just wondering, can you give us the roundabout here? What is this lawsuit and why does it come up now?
Sure. Well, the waiting period, since the Bruin decision came down out of the United States Supreme Court, the test that's implied, that the test that is used to determine the constitutionality of a gun control law is whether there was a historical analog that, in other words, an old law that was around in 1791 when the Second Amendment was ratified, that would indicate that the founding fathers would tolerate the kind of modern law that's being questioned or challenged in court. And the waiting period, there was never a waiting period to buy a firearm back in 1791. And there are no historical laws that would indicate that the founders would tolerate something like this. So this is an issue that's been on CRPA's target list for a long time. We wanted to challenge this for years. We've just been tied up. CRPA has been tied up with Rhodey, Duncan, Bonta, the roster challenge, a number of other cases. And so we just didn't get to this one because of resources yet. So Second Amendment Foundation and some other plaintiffs have filed this lawsuit. So CRPA now will step into a supporting role as a friend of the court and file an amicus brief in this case, supporting the plaintiffs and their claim that the waiting period is unconstitutional under the Second Amendment. So CRPA does this in lots of cases. They're not always a party. CRPA files amicus briefs sometimes in cases in other states that might affect our rights in California. So it's not really new. It's just that this is a new case in Second Amendment Foundation. The Second Amendment Foundation case is a new case that CRPA is going to help support with amicus briefs. And it's important to keep in mind the significance of and the importance of amicus briefs, friends of the court briefs in cases. The parties to a lawsuit, in other words, named plaintiffs in any given lawsuit, cannot pay for, write, or otherwise prepare amicus briefs. They're supposed to be separate entities. Friends of the court is what amicus stands for, that have an interest in the case, but are not parties, formal parties to the case. And so the amicus brief campaigns are very, very important to do because an amicus brief gives the lawyer that's writing it the opportunity to explore a specific issue in much more depth or to raise some issues that are sort of important, but not necessarily directly related to the causes of action that are being litigated by the parties, the named parties, named plaintiffs to the lawsuit. So it's an opportunity to really educate the court and bring some breadth and some depth to the legal arguments that are being made. So CRPA, for example, in this waiting period case, CRPA won't be the only party filing an amicus brief. There will be gun owners of California and whoever else we recruit as we get closer to the time when these actually have to be filed. And then they'll be on a variety of different topics that are relevant to the case, because all of this is designed to maximize the chances of winning by covering all the issues that may not be able to be covered in as much depth as they really deserve in a party's brief because there's page limitations on those. Typically, you can only have a brief that's 20 or 25 pages long, and that's not enough sometimes to cover all the topics that need to really be covered for the court to get the big picture.
Well, I really want to get into that in just a minute, just as far as the programs that exist out there to drive those supports or that support toward lawsuits that, I don't necessarily want to say need it, but that can definitely benefit from it. But going back to this case, leading up to the Bruen decision, we were telling people, and especially after the Bruen decision came out, like put on your walking boots and your party hats. We have stuff prepared. We're going to be coming at the government with a lot of lawsuits. Would you put this lawsuit kind of in that bucket? I mean, we've had challenges to the 10-day wait in the past. I think just as recent as 2018, I don't think it was an all-out challenge to the 10-day wait period. I think it was specifically a challenge to the 10-day wait period for people who already owned a firearm that went all the way up to the Supreme Court. But this isn't necessarily, a new idea for a lawsuit, right? Are we looking at this as we need to take advantage because we do have the precedent set by Bruen in being able to get this law taken off of our books now? Does the outlook look better than it did before? Why does this come up now?
Because of Bruen, because Bruen is a game changer, a legal game changer. It changed the test that applies. And so I don't think a waiting period is going to pass that test of any kind. Now, that's not to say they can't have an instant check, a background check, but those don't take 10 days. This is supposed to be, the theory was when these waiting periods were enacted in various states or at the federal level, that there's a cooling off period, as if you go into a gun store because you're mad and you're buying a gun to go kill somebody or kill yourself. And even Sarah Brady said waiting periods for cooling off periods are they don't do any good. But in particular, if somebody already has a gun or has a CCW so that they can carry a gun, there's no point to a cooling off period in those circumstances. But there's really no point to a cooling off period in any circumstance. It's just a way for the state to make it harder, California to make it harder to buy a gun, and that's why it was on CRPA's target list, as well as, we want to go after the dros fees, taxes on guns, insurance requirements on gun owners, certain safe storage restrictions. Obviously, the CCW has been a huge battle. CCW Reckoning Project is forcing cities and counties to issue CCWs that never issued them before and forcing them to not unduly delay that process. I mean, CRPA has its hands in a lot of legal battles, and we have a lot more on our target list, our dream sheet, if you will, of lawsuits that we want to file. Well, we just need the funding, we need the resources and the time, frankly, to pull the trigger on all those.
Well, and since Bruen happened, the Pro 2A side of these lawsuits has a pretty darn good record. I'm just thinking back to Boland right now. That happened at least a lot faster than I was expecting down at the federal district court. Is there any different kind of expectation we should have for these lawsuits post Bruen, or do you think Boland was an exception in just kind of getting written and having a decision made so quickly?
Well, remember, we sought a preliminary injunction, and CRPA sought a preliminary injunction in Bruen. So those happen pretty quickly. They can be dragged out, as we've seen in a number of cases. But that was about the right time. There was a 3-day court trial in Bruen in front of the judge down there. He asked a lot of questions, talked to a lot of experts, and finally concluded that this whole roster was baloney and was only keeping the latest and safest guns off the market so people couldn't choose a gun that was right for their individual circumstances. And he saw through that. But the state doesn't just give up. The state has appealed. The state is trying to twist the Bruen test, just like they tried to twist the Heller test to justify anything. And eventually, in some cases, it's clearer than in others that there is no justification for a particular type of gun control law. But in other cases, the states are trying to, for example, the semi-auto bans that are being passed in being litigated in half a dozen states right now. The states trying to claim that magazines aren't arms, that the only guns that are covered are guns that are actually used for self-defense, meaning you actually had to pull the trigger, not just have it in your house in case you need it for self-defense. And they're trying to split every hair they can and twist the Bruin decision. So it's not going to be 100% wins until another case gets up to the United States Supreme Court. And the Supreme Court, again, sort of backhands the lower courts and says, stop playing games, stop buying into these borderline frivolous state arguments by state governments trying to justify their laws, because they're not justified under the Second Amendment.
Well, and they're making their way up there regardless, right? So we've got Boland at the Ninth Circuit. We would expect to see the state, if we get a favorable decision, make an appeal on Duncan and Rhodey, I'm sure.
Absolutely, they will be appealed.
Yeah. So, but I did want to circle back to this. So you were talking about amicus briefs really quick and how they can benefit a lawsuit. I know that CRPA has been working with Second Amendment Law Center, not to be mistaken with the Second Amendment Foundation, who's actually a named plaintiff in this lawsuit, to get this amicus brief done. Can you tell us a little bit more about the Second Amendment Law Center, their coordination with CRPA, and just sort of the grander scheme of amicus briefs and the role they play in a lawsuit?
Well, this was kind of a brainchild of me and Steve Hallbrook and a number of members of the CRPA board, that we needed to have this national presence. Second Amendment Law Center is a separate standalone 501c3 that is not controlled by the CRPA. There's no CRPA board members on it except for me. And some of the best and brightest and most experienced Second Amendment lawyers in the country are on the Second Amendment Law Center Advisory Committee. And you can see all that at 2alc.org. But what we realized was that there was a need for a national amicus brief coordinating body that could, because again, the plaintiffs in a lawsuit, the named parties, the named plaintiffs in a lawsuit cannot write or fund or participate very much in getting amicus briefs filed. Those are supposed to be sort of separate groups that come in because they have an interest in the case. They file these friend of the court briefs. So we saw the need to really kind of coordinate that, consolidate that, and pay attention to cases all across the country. So the Second Amendment Law Center is now participating in Illinois, in Delaware, in Hawaii, in a number of other states where we will be, the Second Amendment Law Center lawyers will be, that panel will be preparing amicus briefs to file in those other cases, supporting those parties in those other cases. So it's not just about this particular waiting period case. In California, you have the CRPA is very interested, and in other states, there are other state associations that we're working with, as well as the lawyers on those other cases in other states, to let them know that Second Amendment Law Center is here to support their efforts to recruit potential named amicus, whether it's CRPA or some law enforcement group or whoever it is. We pull a pool together of all the potential amicus, the friends of the court that would want to participate in that. Then we recruit the appropriate lawyer to write a brief on an appropriate topic. And we kind of break out the topics and suggest that these are appropriate things to submit an amicus brief on. And then we coordinate the filing and help in fundraising in some cases, depending on what the resources are of whatever given amicus party that's name's going to be on the amicus brief is. So it's really a national sort of a coordinating body for amicus briefs to support Second Amendment litigation all across the country. It's a 501c3 nonprofit, so contributions are tax deductible generally. But it's, we're already, Second Amendment Law Center is involved in Illinois, as I said, Delaware, some other states, and we're looking to get involved everywhere we can.
Well, how much influence can an amicus brief actually have? Or I guess the better question is, how often do you see amicus briefs strongly considered by a judge? You have you stated that you can only put so much in a document that's 25 pages long. So if the point of this could be to add supporting documentation, Is that something that has as much weight as the briefs?
Well, it depends. It can. That's why they have to be carefully chosen and well written. But sometimes an amicus brief can make all the difference. Uh, Other times you have people who aren't particularly well coordinated or well prepared or well spoken or well written, filing amicus briefs because they care, but they don't really have as much influence. So we're that's why we're recruiting the most experienced, the most knowledgeable Second Amendment lawyers from all across the country to write these briefs, so that they do have an impact. And we're able to look at the issues that are being raised in any given case and sort of do a deep dive into those issues at a length that the parties don't have enough room because of page limitations to do in their merits brief, in their party brief that they file. So you can expand on topics that the court is interested in through an amicus brief, and it can make a big difference.
Well, we're certainly going to add this one to the list of big-time opportunities for us to take our rights back. I know that I've certainly dreamt of a day where I can walk into a gun store and walk out with the gun the same day. So we're going to tag that one up. Obviously, we're still waiting for Judge Benitez to offer us the decision on Duncan and Rhodey. Chuck, I really appreciate you coming on and sharing this stuff with us, and we're going to have to get you on, I'm sure, soon enough to talk about those other lawsuits. But thanks for being with us today.
My pleasure, guys. Thanks for having me, and thanks for supporting the viewers. Thanks for supporting the CRPA and the Second Amendment Law Center.
And if you want to continue and support CRPA and these lawsuits, we are taking back our rights here in California. One small way you could do that, again, you can like, share, and subscribe to these videos. We want to get as much traction on this information as possible. Let everybody out there know who is fighting for them and what is being fought for, and you can definitely help us by doing that. Thank you guys again, and we'll see you in the next one.